Good morning, everybody. Welcome to this presentation of Drugs and Alcohol in the Workplace, sponsored by Alameda County Workforce Development Board. My name is Stephanie Neely, and I'm the Marketing Director here at CEA. While we wait for everyone to file into our virtual room, just take a moment, make sure you have some water, coffee, snacks, whatever you need to stay energized for all the information that's about to head your way. And before we begin today's presentation, I'd like to go over a few housekeeping details with you. Your audio will be muted throughout the presentation, so we ask for your participation through the chat box. If you have any questions about the presentation or any questions about the handouts or technical issues, you can put all of those in the chat box. Handouts for this presentation were attached to the reminder email that was sent out with this link. If you need them resent, please put your email in the chat box and we'll make sure you get them. If you experience any other technical difficulties, please just let us know and we'll help you troubleshoot. Because your feedback is very important to us, please complete the survey by accessing the QR code at the end of the presentation. It shouldn't take more than a minute to complete, and it provides us with valuable feedback that we use to constantly improve our webinars. This presentation will be recorded and available through the Alameda County Workforce Development Board. Before we start our presentation, we have a word from the Alameda County Development Board from Carmelo San Mames. So with that, take it away, Carmelo.
Hi, everybody. Thanks for joining us today. We're so excited to have you receive some of this important information. I just wanted to go over the hotline with you, which is another service that we contract with CEA to deliver. And so this gives you information if you have follow-up questions to this or anything else related to HR, employee handbooks, sick leave, harassment prevention, so many other HR topics. Just reach out, give us a call at the phone number, and they'll get back to you either live or within 24 hours. And please use the service. It's available to all Alameda County businesses.
All right, thank you very much. And our HR expert today is Astrid Servin. She is also one of the friendly voices that you could talk to when you call into our hotlines. So Astrid, take it away.
Thank you, Stephanie. Thank you, Carmelo, and good morning, everyone. At Alameda County, we're happy to be here with you today to provide this important training and give you some tips, advices, some practical steps, and good practices for your business as it relates to drug and alcohol in the workplace. So as they mentioned, you have that HR hotline, which is amazing. If you need additional support, more and beyond the hotline, we also offer other kinds of services in the HR field related to anything HR related, actually, from the beginning, from onboarding all the way to termination and everything that comes in between. We are an HR consulting company where you can become a member of ours. So if you need additional support, more support than what the hotline offers, consider visiting employers.org. We also have a lot of free resources for our employers out there in California. So if you find yourself needing just additional tips and tools, again, visit our website. We actually have a drop down that says free employer resources where you can find a lot of things for free. But again, if you need additional support in training, in investigations, in more handbooks, things like that, we also offer a membership. What we are not is a law firm. So we are an HR consulting firm, not a law firm. But so this presentation and everything that we say to you should not be relied upon as legal advice. It is educational. And we want you to consult with your own attorney when something of legal significance comes up so that conversation can be confidential and privileged, and you will have a better way of deciding which way to go. A lot of times we can get you to the place where you now can talk to an attorney, and so we save you time and money when you discuss certain things with us, but then we might get to a point where we'll say, we recommend you now take this to an attorney for legal advice. So definitely give us a call for HR related things and for your trainings. So you do get some trainings throughout the year, and we're happy to cover drugs and alcohol in the workplace today. We're going to talk about the impact on employers. What are the obligations an employer has to have as it relates to drug testing and reasonable suspicion, things like that. We'll talk about the new cannabis protection that was passed last year and went into effect this year. So what implications does that have now that we have a new law governing us in cannabis world? And then employee rights concerning drug testing, because they do do have quite a bit of rights, actually. And so you need to know, when can I and when can't I drug test? We'll talk about that. And the big one, reasonable suspicion. There are certain things and factors that go into reasonable suspicion. We'll discuss those. And if you haven't implemented a drug-free workplace program, we're going to start with that as to why you should have a drug-free workplace program. Even if you don't do pre-employment, which a lot of employers are going away from pre-employment drug testing, it is still a good idea to have a drug-free workplace program in place. We'll talk about why and the things that should be in your policy as well. So let's get started with this. If you have a testing program, if we're actually going to have a way to test employers, why should employers consider a drug and alcohol testing program? It's going to protect your business. It's going to protect your employees when dealing with things such as productivity, performance. Those are things that are impacted by this really real issue or concern when it comes up. And when it comes up in your workplace, it can be a scary thing. It can be a very problematic, emotional, high tension thing that can happen in your workplace. So we need to be equipped and armed with what we're going to do should that happen. And if we're going to be able to test, we need to prepare for that. There are legal compliance, and certain industries are mandated to test, and so we're going to talk about that. It's going to reduce liability if this becomes an issue in your workplace, workers' comp, safety of others, all that kind of stuff. It can be a very scary thing, again, when it happens, and you really don't have time to sit there and think, do we have a policy? You should already know that answer. So there may be some very low cost in establishing this policy and this kind of program and actually drug testing. So we really should look into it and see why the need is there. So why is the need there? Well, we have this alcohol and drugs are very real in our society. And so we're going to talk about some statistics. This can become a very big real problem within our workplaces. As you can see here, 16.5% of people are unable to work due to health problems related to alcohol. And it increases the chances of attendance problems. As you can see, there's many deaths attributed to this real problem with alcohol abuse every year. The New York Times reported drinking during the pandemic increased 60% among women. So these are statistics that have shown us, okay, there's a real problem. People working from home, different reasons why this happens in the workplace. So we need to be armed. We need to be equipped. Some drug abuse statistics here. 63% of people who self-report misuse of prescription pain relievers were employed, full or part-time. And it's estimated approximately 18% of the population, I think it's a little higher, has used cannabis, especially now that it's legal in the state. So, again, this is something that's increasing every year. Those statistics are just going to go up and up. So cannabis now has special compliance considerations and protections. So just because it's legal in the workplace, just like alcohol is legal, it doesn't mean you need to allow it in your workplace. But you do need to know how you're going to react to it when it comes up in your workforce. So we'll talk about that coming up. Now, there are some industries that require you to drug test. The Department of Transportation has such regulations because they govern employers who conduct drug and alcohol tests because of the type of worker that you have. So anyone in the transportation area, aviation, trucking, railroad, mass transit, pipeline, these types of industries that are transportation industries are going to be mandated more than likely by the Department of Transportation. So if you have workers who fall under the Department of Transportation, you must follow their program. You must follow their rules. They actually have the method and procedures of what the minimum is of what you need to do. And it's going to cover 12.1 million workers out there. So it's something you should be familiar with and know. And they publish those rules on when and where and how, pre-employment, post-employment, and it's going to cover all that workforce. So just know you should have, if you have a drug testing policy, you should have a general one. And then if you have, let's say, drivers that are governed by the Department of Transportation, have a separate policy for them that is separate and apart from your regular workforce, because some of those we cannot, and especially if they're federal rules, can't do in California unless those drivers fall under Department of Transportation. So we always advise have a disclaimer. This is for the Department of Transportation workers. workers, and this is for the rest of your workforce. For example, people who are in the office, they're not going to be governed by the Department of Transportation. So it's estimated there's a real cost to these issues, these concerns of alcohol and drug in the workplace. It's estimated that employers lose over $81 billion due to absenteeism, tardiness, performance issues, productivity due to alcohol and drug abuse, and healthcare costs as well. It says 25 billion lost productivity, 25 billion also lost in medical care costs. That increases, that goes up. So there is definitely a concern here. So, we want to protect our businesses from this type of misuse, from this type of concern. Termination, so talking about when we do terminate for drug testing, if we have a policy, the employee automatically is ineligible for unemployment insurance benefits if we do it properly. If we properly drug test the employee, have a drug test program in place, conduct the drug test with their consent, it turns out to be positive, we're terminating the employee, that makes that employee ineligible for unemployment insurance. So that's good news for the employer. And we want to make sure that we do it properly, however, because if it's found that we were improper in how we conducted the test, and we'll talk about the proper way to test in a minute, then they may be eligible for unemployment benefits. Another great thing for our employers is Labor Code 3600 that states a company is not liable for workers' comp injuries, including death, which hopefully that never is the case, when proximate cause is alcohol intoxication or illegal drug use. So another great reason why we would have this program in place, if there happens to be harm to self or harm to someone else, workers' comp related, and there was drug use, we did test and it was positive, then the company is likely not to be liable for those injuries. Okay, let's move on here to cannabis use, because this is, 2188, this is Assembly Bill 2188 passed in 2023, and they gave us a whole year. They passed last year and that went into effect January 2024. They gave us a year to kind of figure it out. And it didn't go so well. A lot of our companies and drug testing companies didn't quite figure out how to test for this cannabis in the correct manner. So before we get to the drug testing, let's talk a little bit about the Assembly Bill. This is under FEHA. So FEHA is the Fair Employment Housing Act. And this is a law within California's Civil Rights Department that says we employees and applicants are a protected class now for when they use cannabis use outside of the workplace. So this is a big change in the status quo. Up until now, courts had said that California employers could choose to test, terminate on cannabis, and the reason was because federally it's still illegal, and so we can test for it. But that all changed as of January 1, 2024. The new protected class protect applicants who consume cannabis off-duty and off-site. So that means that we can't discriminate or take adverse action against an employee or an applicant for using cannabis while off-site. We can still take some action if they're doing it on-site. But if they're doing it off-site and away from the workplace, this becomes something that they're protected for. So it does not permit them to possess, be impaired by cannabis. The same way we wouldn't allow alcohol, we would not allow cannabis in the workplace. We do need to make a little bit of a difference in our drug test policy just because this is a protected class. So in your handbook, for example, you're listing all your protected classes: race, pregnancy, disability, gender. This is now one that you need to include for 2024. Cannabis use off-site. So never thought I'd see the day, but never say never in HR because we're in California, and never a dull moment here. So the new law does not protect certain industries like the Federal Department of Transportation we talked about. It also does not apply to employees in the building and construction trades, meaning they can drug test the same manner they always have, and they don't have to exclude cannabis from their panel. Positions requiring a federal background and investigation or clearance are also exempt from this. And this law does not interfere with any other state or federal law that requires you to test for that. So again, those Department of Transportation transit workers, you can drug test them in the same manner you always did. You don't have to differentiate in the test. So let's talk about that. testing for cannabis. Our employers, and if you'd like to participate in my little poll, please utilize the chat. You can chat with me personally, or you can say it to everyone in there. So testing for cannabis. Are employers permitted to test employees and applicants for cannabis? I think I might have given it away, but let me know what you think. Are we allowed to do that as employers? Go ahead and take some time, find the chat box if you'd like to chat with me there. So I got a couple to me here, yes and no's. So let's talk about the answer to this one. So it's yes and no. So both of you are correct. It is yes and no. When drug testing is permitted, so let's say you're not exempt from any of those, you're allowed to drug test. You can test for the THC, which is the chemical compound in cannabis that indicates impairment, and that's the part that causes the psychoactive effects for you to be high. And so if you test properly for cannabis, then you're testing the right kind of test is only going to detect the THC in the system, meaning you're actively high right now. You're actively under the psychoactive effect of cannabis, meaning it's very current within the last few hours. You are still allowed to test for that. However, it might be difficult to find a clinic or a testing site that will only test for that. That's where it becomes difficult. And what we've found through our information is that the saliva sample is the best way to test for that psychoactive within the few hours. Because if you do the other test, the one we always have done, the urine test with the panel, that one is not compliant anymore, because that one actually detects the non-psychoactive metabolites, which we cannot test for, because this new assembly bill does not allow you to test for that non-psychoactive metabolite, because that one is the one that gets stored in the body. You know, this California legislator has educated us HR pros on this stuff. So that the non-psychoactive metabolite stays in your system for a few weeks. And so if we do the normal panel with the urine, then that one is testing for the wrong item in cannabis use, and that is deemed to be illegal. But someone in the chat said, but if you're in the construction industry, then the THC does not apply. Right. So if you are exempt, and just make sure, check with your legal that you are exempt under the definition of construction, if you actually meet that definition, and more than likely you do. So this wouldn't apply. You can still test for cannabis in the same way you always did. But for all other employers, and also if you have, for example, non-construction workers, if you have office personnel, then this wouldn't apply to you. It's only for those workers that are under the law the way it is written there. So make sure, what I would recommend is talk to your clinics out there to ensure that you are testing, that they are using the correct test out there, which again, within the last 4 months, we haven't seen too many clinics who have been proactive in getting the correct kind of test. We have seen some getting the saliva sample. And what we have seen has become pretty normal is employers say, just take out cannabis completely from the panel if they're able to. We've heard clinics charge more sometimes for that, which I would say find another clinic, because that's pretty, tricky for you to be doing that, knowing that we can't test for that anymore and now charging more because of it. They should just be compliant with the law, knowing that they can't test for that. So look around, shop around, definitely talk to your workers' comp clinic or wherever you send your drug test people to make sure that they're not testing for this so that you are compliant. So talk to me about this. Can we still have a zero tolerance policy for using or possessing cannabis at our workplace? What do you all think? Can we still have a zero tolerance policy for using or possessing cannabis at our workplace? And so I see some yeses. Right, good. Thank you for responding there. So yeah, you can maintain a zero tolerance policy, including for cannabis. So this means you do not have to allow employees to use, possess, be under the influence of cannabis while at work, or even reasonably accommodate, because that comes up sometimes. My doctor recommends this, I need to use this, I'm actually going through treatment right now, and this is for medical purposes, you must accommodate me. We don't. This new law that passed does not require employers to accommodate for cannabis use while on the job. They can use it after work, but not while they are at work. So check your current drug testing policy and make sure that it doesn't restrict personal use, that we're training our line managers or supervisors or leads in that we can't tell employees that they can't do this. If you're seeing them going into a shop while you're driving around, you cannot use that information against them because there's a whole other thing to reasonable suspicion testing, which we'll talk about. So this is a new one, the CBD products. This has become very popular, and they're over-the-counter CBD products that have not been approved by the FDA. So, and we've through the research here, 43% of CBD oils tested actually had THC in them. 3% of CBD oils tested had more THC in them than what was labeled. And that came from the American Journal of Medicine, which means even if you're doing the proper test and the person doesn't seem like they may be impaired and they're actually maybe an applicant who's applying, you need to know, applicants need to know that that's under their kind of running their own risk in testing positive for cannabis use if they're just using the oils. That does not excuse a positive test for testing the right way. And there's enough THC in the system. The research shows that even through the CBD oils, there's enough THC there that can impair a worker, and that would violate your drug test policy. So they're not protected just because it's a CBD product, and that's their excuse, or that's what they're using. So let's talk a little bit about drug testing and the law. What does the law allow? Because we are in beautiful California, which we're all here because we probably love it, but there are a lot of restrictions that we have as employers that restrict us. We have wonderful things too, like our California Constitution. So this is a great one. This is Article 1. All people are by nature free and independent and have inalienable rights. Among these are enjoying and defending life and liberty, possessing and protecting property, and pursuing and obtaining safety, happiness, and privacy. So that's wonderful. But that one word that's bolded there, privacy, can cause a little hiccup when it comes to employers and implementing drug policies. So California courts, we're going to talk about this, have ruled that because of that word privacy in the California Constitution, that kind of limits what we can do as employers and how we conduct our drug testing. It's meaning that it's still allowed, but we have to have a policy in place, and we have to have uniformity, we have to have consistency, and we need to make sure that we tell employees, disclose to employees that we'll be doing it, which means something like a random test may not be allowed, and we'll talk about that. So the key here is to disclose when we will do it. California is not the only state that has this kind of thing in their constitution. There's 7 other states that also, and I'll just read them out here because I think I have them. Alaska, Hawaii, Illinois, Louisiana, Montana, and South Carolina all have something in their constitution that also dictates or talks about privacy along those lines. Okay. So I talked a little bit about disability, and when an employee is saying, look, I'm taking this for, and they rightfully may be taking it due to a medical procedure that they're having. And so, in California, we have FEHA, the Fair Employment Housing Act, that's governed by the Civil Rights Department. And federally, we have the ADA, the Americans with Disabilities Act. Both of these things help employees who are disabled, who are undergoing treatment, who are need accommodations, but neither the federal or the California law protect individuals who currently use illegal drugs, with the exception of cannabis use when it's off-site. So just know that this isn't something that they're allowed to have a note that would excuse them to be impaired while at work. But definitely you can, if they tell you, hey, look, after work I do this, okay. And when it can become tricky is if they say, for example, using this as an accommodation, I may be late to a shift because of it. If something like that happens, get legal counsel, give us a call through the hotline. We'll kind of walk you through it. If there's a medical form that's attached to it, we're not excusing the cannabis use, but they may need, for example, an accommodation of a late start because they sleep in or they're late to their shift for some reason, and the accommodation is based on that and not the cannabis use. Remember that former abuse with rehabilitation, so if someone is in rehab, that is protected, both for the ADA and FEHA. So we do have protections, a Rehabilitation Act actually, that protects employees if they're undergoing rehab. So now we know that you use and possibly abuse drugs or alcohol, but you're receiving rehab. In that case, that is a protection that we need to accommodate. Employers with 25 or more employees, if you're a larger employer with that many employees, you have to accommodate employees who want to voluntarily enter rehab. So if they say to you, look, I messed up, I've been going through a hard time, and I actually need to go into rehab, you do need to allow for that and allow an unpaid leave for them. You do need to allow them to use vacation and sick if they want to, but you do need to allow that time. And that time is like, it could be a very long time. There is no limit on that. So next we'll discuss kind of the 4 typical circumstances in which employers will drug test. We have the pre-employment. We'll go a little bit more into detail on how we implement that and what goes into that. So that's before you hire an employee. We're going to do pre-employment. There is random testing. Some employers do random testing, and you kind of know how that's going to go because we read Article 1 of the Constitution. But we'll talk a little bit more about that. It doesn't mean it's illegal, but we'll talk about the risk there. And then we have reasonable suspicion. What does reasonable suspicion mean? What does that entail? And how do you do it? Now we'll talk about that. And then we have post-accident. Post-accident, a workers' comp injury, and very common, we will post-accident test. What are we allowed under the law to do for that? So remember that privacy verbiage in the Constitution. So because we are disclosing in our job postings, in our policies, that we will pre-employment, before we hire you, do a test, we are now disclosing. And so we're okay to do that and be in compliance with the Constitution. And that has been ruled by the courts. So that's good. So we can require an applicant as a condition of employment. And remember to say that. You really need to say, we are offering you this position contingent upon passing a drug test. Do not start them. We've had employers do that before we receive the results, and then you're in more hot water because you started them without getting the result first. And not considering a medical examination as long as it's not in conjunction with any pre-employment physical. So this is not considered that. It's because sometimes employers do medical exams and all that before hire, which are very tricky to do in California anymore. Under circumstances, yes, but a lot of employers are going away from that. But this isn't considered that, so we're okay there. Must be after offer of employment and before work starts. Again, do not start that employee because, again, you're going to be in a difficult situation to terminate that employee if you've started them. And then consult with drug testing provider to ensure cannabis testing is compliant, like we talked about earlier. Okay, so some to-dos here for pre-employment. Notify all applicants. Be consistent in your testing. Do not drug test some and the others we don't. And for these higher positions we don't, but for the lower positions we do. That's not going to fly in a pre-employment testing policy. You need to be consistent. Use a designated collection site. Make sure you know that they are compliant, like we talked about before, and that they follow certain things like a chain of custody form, because that's going to ensure that the sample is properly secured and handled and tested. That chain of custody kind of it handles the sequence of who handled that specimen, and that way it wasn't tampered with, and we are okay in court if someone was to challenge us on that result. So we want to make sure it's only conducted by authorized personnel. We're not doing these drug tests like it used to be back in the day where people would do it at work and the HR person would handle that drug test. Can't do that anymore. Privacy during collection, we want to make sure that is all. So again, no tampering here. We're protecting the integrity of the test during the whole process so that if it is challenged, we followed legally the rules and what we needed to do. Make sure that they have that chain of custody. If you have a proper clinic doing this, you shouldn't have a problem with this. Now let's talk about random testing, because a lot of employers want to do it, still do it, can't believe we can't do it, that kind of stuff. So it's not illegal, but the burden of proof that you are justified in random testing is very hard to meet. First of all, every employee has an equal chance to be tested. You can't just say, well, I'm only drug test, I'm only going to do a random sampling of the people in the warehouse, or only the drivers, or only certain departments get drug tested. So every employee has an equal chance of being tested. The employer has to prove a compelling interest to justify intrusion into that employee privacy. Because we're not disclosing when we're going to do it, we're saying it'll be random, then you really have to have that compelling reason. And I'll tell you that a lot of companies have gotten in trouble because when they try to prove their compelling interest, which sounds very justifiable, if I'm being honest, the courts have said not enough. And so there was a court case here. I wrote down Luck versus Southern Transportation. The court ruled that instituting a random drug test program because it would deter employees maybe from using drugs while at work. They did it for efficiency, competency. They wanted a drug-free environment. They cited rule enforcement and ensuring public confidence in them. That's why they did random testing. Court said not enough. Those were not compelling interest. I have yet to find what a compelling interest could be. I would imagine it goes along the lines of safety in workplaces, but you really have to do that. So it is illegal in some states. So if you have employers and in some municipalities, so San Francisco Bay Area, there's actually laws against doing random testing already. So legally, in most of California, we're okay so long as you follow this. But again, very much not recommended, not as a good business practice to do. It's usually limited again to positions that are critical. So the industries like public safety, protection of life, property, national security, those kinds of very high safety positions, okay, you can drug test those. Those are the compelling interests there. So if you still desire to institute a random drug testing program for your company, other than those subject to the Department of Transportation or these highly skilled positions here, you do so at your own risk. I would really recommend and advise you seek counsel if you're going to do that random testing. So again, these are some areas where we are allowed to do it. It is a compelling reason here. Truck drivers, pipeline workers, aviation personnel, correction, because they have the lives of many in their hands. So these cases have been brought to courts and they have had a lot of legal scrutiny on them and they have said, yes, okay to random test. But again, for normal employers, a little bit harder to prove. So the other one we have is post-accident testing. And the courts have generally, the courts have said that that's okay, but there has to be reasonable suspicion that an employee involved in an accident was under the influence of drugs or alcohol, or if the accident was a very serious one. So we can do post-accident, but we can't have a blanket policy that says I will drug test everyone who has a post-accident workers' comp, because we still have that privacy thing, because we still have it has to be a reasonable suspicion, and that's what the courts have ruled. So again, it's not a law, but the courts have ruled so many times in this way that we're going to recommend you really have that reasonable suspicion tied into the post-accident when you're doing it. So again, only when there's reasonable suspicion that employee was involved. So let's look at a scenario here and then you weigh in on this. You can use the chat if you'd like and chat with me or with everyone. So this scenario is reasonable suspicion. Do you think there's enough here? Your employee goes to the break room and to get some utensils. When they open an overhead cabinet, a container of coffee falls out and it hits them in the face, very heavy coffee, and it breaks their nose. So what do you think? In this case, do you have reasonable suspicion to request a drug test? And we're looking at the standard of, is it serious? Is there a suspicion here? So likely, good. Everybody answered no. Likely not. There is no other factor here that we've discussed in this specific limited scenario I've given you that would give you pause or suspicion that we really need in order to drug test. So not enough. But let's look at reasonable scenario number 2. One of your employees is driving a company delivery van to a customer's house. On the way there, they fall asleep at the wheel, going off the road and hitting a median, causing damage to the van. In this case, do you have reasonable suspicion to request the drug test? What do you think based on our standard that we've been discussing? And, because I just gave you a no. So most of you say yes. I have a couple no's on there. And I would say because it is a serious, so that's the burden here is a serious accident, you would have to maybe talk internally about your policy of what's serious. How do you define that? Maybe it's a dollar amount of damage. Maybe it's causes a harm to someone or someone else, the safety part here. And because he's a driver, all those things would elevate this to likely be something that you can legally drug test for. Excuse me. So reasonable suspicion has been defined by one court as something less than probable cause, but more than mere suspicion. Excuse me. Always happens, never fails. Excuse me. Reasonable belief employee is under the influence are some objective factors. you may require further investigation based on your observation. So we're going to talk a little bit more about what constitutes reasonable suspicion. How do you know if you have enough to drug test? So let's look at the determining if this exists or not. So what might constitute reasonable suspicion? A lot of different things. I mean, we put a few things here, but the list is exhaustive. We actually, if you're a member, we have a checklist. Very nice to do checklist that goes through everything. So if you're a member of CEA, you have access to that under HR forms. If you're not a member, you can still I would recommend making your own checklist so that you have when the time comes, especially if you're the HR manager or you're the manager and you have a lot of line managers or leads out there who may or may not be there when this happens, have a checklist in place. Some things like alcohol or marijuana smell, again, might not be enough. So we're going to talk about, these are just getting you there where you're creating this reasonable suspicion. Could be lapse in performance, inability to appropriately respond to questions, physical symptoms of alcohol or drug influence. I mean, again, it goes on, right? Unusual mood swings, unusual talking speech when you're talking to them. Is their speech slurred? Maybe it's out of a character or unusual. You have employees who talk a lot, but maybe this is unusual for this employee to talk a lot. Or maybe they talk a lot and now they're not talking at all, and that's unusual and out of character. Of course, if you have someone stumbling, staggering, acting erratic or violent, these are all indications that now our antennas are up. We need to consider whether we have enough or not. Okay. This may not be enough. Again, having one of these things, maybe even two, is not enough. So that's why we need to consider the checklist, because people might exhibit these things, especially marijuana smell. If they did it last night or they're wearing clothes, it may not be enough. So this is just one factor. So you're going to have to, at this point, when your antenna goes up and you have these items on your checklist that went off, now you got to investigate. So you're going to continue this process by meeting with the employee. Okay, so you train your supervisors, your leads, whoever's in charge, to meet with the employee, because this is going to give you an opportunity to converse with them and observe how they're responding to you so that you can observe further symptoms of impairment. So you may already have the alcohol or cannabis smell, or you may see them slurring their speech. So now we're going to engage with them to see what else are we observing. And that what else that we're observing is going to be documented. Now you're going to go and ask another manager. So we would love to have two managers conduct this reasonable suspicion investigation, and you're going to independently just say, hey, give them the reason why your antenna went up and why you're suspicious, and allow them to independently on their own go and talk and engage with the employee, or maybe just observe that employee. And so they should independently determine, okay, I see what you mean. This is what I observed. I mean, they may have observed, again, from a different perspective, and that way someone cannot allege that you individually have some beef against them or are discriminating against them because you don't like them. So always best to do something like that. And then maintain appropriate confidentiality of information. You're not going to go and say, oh my gosh, yeah, did you see that guy in the break room, and just tell people and go tell subordinates or colleagues of that employee what you've observed. That would not be appropriate, because again, we need to maintain confidentiality, as we do with a lot of employee situations in the workplace. So have a way for these managers to contact HR or management or the person trained in this, especially because I'm going to tell you, a lot of times it happens when you're not there. It seems to be kind of the way it goes. A lot of times it happens at night if you have night shifts. So we used to, when I was on the field, have like a binder that had our whole policy on it, and it was kind of like an emergency binder, similar to when we hiring, when you're onboarding someone, that's your onboarding binder. We had a drug test, reasonable suspicion drug test binder, and we would put on there all the information. The checklist would be on there so that each manager independently would check off what the suspicion was, and then it give a kind of a 1 to 2 sentence of what they observed and why we're now escalating this to the next step, which the next step would be to and what the employee said. You want to see, I talked to the employee and this is what they said. How did they respond? You're going to put that on your checklist as well. Give the employee an opportunity to respond. Is there a reasonable explanation for their behavior? They may give you a really good one. I've worked in HR a long time, and I've actually been like, oh yeah, they're testing positive. I mean, no, they are. And then I talked to them and they provided a very good, reasonable reason why something's happening. Everything from I'm going through some domestic violence situation at home, all kinds of things. Or I've also had people disclose to me, yeah, actually, you don't even have to drug test me. I'm gonna fess up to it. I have a problem and I need to go to rehab. And we were a large enough employer where we had to say, okay, here's the information on rehab. We couldn't terminate that employee because they asked for help. And so that is something legally, if you're again an employer with 25 or more, that you have to offer that rehab program, not pay for it, just offer it. So if employee's explanation does not explain your observations and the employee is exhibiting multiple suspect behaviors, then you probably will have enough to reasonable suspicion. So that, think of that form, that checklist that you have, as something that will be scrutinized if this employee challenges you. So look at it carefully and make sure that you have enough there in order for you to move on to the next step. So let's see. And when you talk to that employee, tell them why you're talking to them. Remember, we always have a right to talk to an employee and engage with them. This is the reasons why I am talking to you. I've observed so-and-so, I've observed this and that, and how do you respond to that? And again, always be thinking, if this document, or if I am being challenged by even a jury, let's say, what are they going to say? If you have a very well documented, again, two independent people, you're going to have reasons why, justifiable, why you sent them for a test. So if challenge and issue goes to the California court system, it doesn't actually go to the agencies that handle, for example, discrimination. Sometimes we have agencies that help us, the Civil Rights Department or the EEOC, and it goes them. Well, not with this kind of test. If an employee is going to challenge why you drug tested them, it goes straight to court. So what would a group of strangers, meaning a jury, think of why you did this? So think about that way before you drug test. Don't just send them off. Make sure you have something in place. So some elements of a compliant drug test policy, and again, take these slides and you can conduct your own policy based on this. You're going to state the reason for the policy. That lets your employees know the reason why you're instituting these rules concerning drug and alcohol, how it affects performance, safety, attendance, that kind of thing. You're going to talk about the unacceptable behaviors related to drugs and alcohol, because this lets your employees know what specific things you consider prohibited. So possession, use, working under the influence, driving company vehicles, for example, under the influence. You're going to list them all, and you can say this is not exhaustive, but some examples on there. You're going to give employees reasons why a test may be required. You should include a requirement that your employees must notify you if they're taking any kind of prescription drugs, because some of those narcotics they're prescribed can definitely impair them, and that's what's come up with me, like, oh, I have a medical note for this drug I'm taking, and yeah, it makes me slur my speech or it makes me smell funny. And they were able to provide substantiation, which they should have disclosed beforehand, because that does create a safety risk. So we may not have that employee be working there even if they're under the influence of a prescribed drug. So again, list the reasons for why a test will be required. And then what will happen if they fail or refuse a test, because that comes up probably more often than not. An employee will say, I don't want to test. I refuse to. I'm not under the influence. I'm not going to go. So list in your policy what happens with those employees who refuse to test. What are you going to do? Are they automatically terminated if they refuse to test? Likely, yeah. So they're going to know, but if they have a policy in place, they're going to know that if they refuse to test, our policy says you are terminated. If absent a policy, it's a little bit more risky. It's a little bit harder to prove that that's what you were going to do. And then list your rehabilitation options that the company offers. If you have to mandatorily provide that, make sure you put it on there, and reemployment opportunities as well. If you're 25 or more employees, you have to reasonably accommodate employees who wish to enter voluntarily into a drug rehab program. They have to, again, provide substantiation. It's all in the up and up that they're actually going to. And this is unpaid time. They can use their benefit time, but there is no, similar to CFRA and FMLA, where there's a cutoff. With this one, there isn't. Usually it's not that long, but we want to make sure you know that they can continue to enter one, and so long as they're protected with substantiation, as long as they have substantiation, they are protected. So some drug-free workplace programs here. Your drug-free workplace program contains guidance to your management team on how to respond. This is more of an internal policy that you're going to have. So make sure internally you have a way of knowing when we require this, and then the testing procedure. Again, have that binder, have something in place where it talks about who's going to take this employee to get tested. How are we going to do that? It's so much easier now that we have Uber, but it used to be a manager had to go and drive the employee to the clinic, because if we think they're impaired under the influence, you cannot have that employee drive themselves to the clinic. So have that plan in place already. Where is the lab? Where do we use it? Have the address to the lab there, along with your employer number, whatever that is that authorizes that test. The location, make sure it's convenient. If you have remote employees working out on the field, that we have clinics that can handle them. And then the level alcohol company considers to be positive, and the THC levels that you're going to work out with your clinic as well. They typically know that. And then employee status pending results. So what do you do with this employee? Once they're at the clinic and you drug test them, you need to know how are we going to get them back home? Are we going to wait for them? Are we going to send an Uber back? Are we going to make sure, are we going to give them a voucher? Do we call their emergency contact to come pick them up? Those probably not, because that's privacy, but those are the things you got to work out in your policy ahead of time. And then again, maybe you get to the clinic and now your employee is refusing or to consent to that test. They don't want to do it, or they're there and the clinic calls you and says they don't want to test. They actually just called an Uber themselves and took off. What are you going to do with that? So manager's role concerning reasonable suspicion testing. What is that manager responsible to do? And then have the forms available. You have to have the authorization forms in that, again, that binder, because at the time that it happens quickly. And so having something in one location, one place as an emergency, because it is an emergency, you need to be able to arm your management team, your company with that. Absent that, people are frantic. They sometimes call us saying, I'm actively having this happen, and it's hard because we got to talk them through, okay, do you have this? Do you have that? And we can absolutely help you, and always call us if your emergency happens between 8 and 5. That's what the hotline is for, and we'll kind of walk you through some of this too. But having this program in place is going to save you a lot of time, and it's going to give your management confidence on what to do should this happen. All right. So before you begin testing, your employees must be aware of your policy. So again, you know about the reasons to test, what tests you want to conduct, and the guidelines. But before you begin testing, you still need to inform your employees. So have a policy, a handbook, that they're subject to drug testing and under what conditions. I'll tell you, a lot of employers have stopped pre-employment drug testing, and really the only testing they do is reasonable suspicion testing. So always have at least that policy in your handbook for emergencies as they come up. Talk to your drug testing facility. If you are still looking to implement, I mean, you don't have one, then look for those certified facilities and clinics. Usually your workers' comp clinic does drug testing as well. That's something that they offer. So look towards that and see if that's an easy solution for you. And make sure that they use a multi-step process to confirm positives, meaning they're going to, if it tests positive, they're going to run it a second time or through a different test site before the facility confirms that it's positive. And they know to do that. So check and make sure that they do have a multi-step way of doing that, and that there's a medical review and officer review, medical review and officer review. It's an MRO, it's called a medical review officer, and they should personally review the test result as well as conduct possibly an interview with the donor to determine if that is a true positive test. You have to have written confirmation. Some clinics will call you and say the employee tested positive, but they should follow up with something written so that you have documentation other than just that verbal conversation from the clinic that they tested positive. So what about these? I mean, they don't look too familiar for me, but some people have done this in the workplace where they have these types of tests that they do, and they are less expensive than going to a clinic and having a lab do it, but they're not being reviewed by an MRO. We're not having the confidentiality forms, the chain of custody, all that. So in the end, this is going to be a more costly way of doing a drug test because you're not compliant, and it's going to result in a possible charge. And so I would not recommend these types of tests be done, and even at the clinic they know the correct and compliant test to do. Remember confidentiality. Drug testing documents are confidential records, so be careful and limit the use of who can have access to this. It has to be maintained in a private file that's separate from the employee personnel file. So have like a pre-employment or a drug test or a medical file. Medical file usually works. That's separate and apart from the personnel file. You have to retain this for the same period as you retain any kind of employee medical record. So make sure that you have a way to control that and know how long to keep that record for. Generally, these files are kept for a minimum of 5 years after the date of employment termination. That's typical. So when a testing event occurs, inform the employee with reasons why the testing is happening. You have your policy in place, you have the program completed, your management team knows how to carry it out, and now you're actually at the time where you need to carry out a test. And so you're going to inform the employee, we're actually going to be testing you based on the information that we have. We do need your consent, employee, so your form is going to have the consent, or the clinic will have that consent for you as well. So you're going to allow them to consent to that. You're going to transport them to the facility. Again, it could be you that takes them. It could be an Uber driver that takes them to the clinic. They are responsible for then, if you do an Uber route, for actually taking and conducting the test. Call the clinic ahead of time. I have an employee who's going for a drug test, and follow that through. Did the employee make it there? Did they leave? What happened? And then have transportation for home. So work it out with the clinic to call the Uber to pick them up afterwards, or have someone there. It could be management, it could be a friend, someone who is going to transport them home. We want to make sure that we close that loop and we don't just leave them at the clinic. That would be awful. So let's make sure that you have thought this through, that you have that policy in place in your guidebook, in your handbook, in your policy. So some key takeaways here. Remember, post-employment drug testing requires a compelling reason. So if you're going to be doing this, you should, again, have worked out the reasons and the standards of why we send employees to drug testing. And then enforce your policy consistently and without prejudice, meaning we can't just do some employees and not others, certain departments and not others. You have to be consistent when applying that. The number one reason we get claims actually related to drug testing are discrimination claims, which are handled by the Civil Rights Department and not a court case. So the Civil Rights Department will be involved if you're discriminating against the employee, and the employee will likely make that accusation versus your drug test policy was incorrect. They may actually cite discrimination as the reason. So your policy could be beautiful and compliant, but if you're only testing certain people, or you give the employee the appearance that the reason you tested them was for a discriminatory reason, they're going to file that claim. And those are very costly and difficult and emotionally hard to handle, those claims. So maintain employee confidentiality. Again, ensure you know who has access to those files. Keep them separate. I know some of you are very small employers, but we still want to keep them separate from the personnel file. They shouldn't be in there. An employee has a right to their personnel file if they request it in writing, and this should not be in there if they're requesting that personnel file. All right, so let me see if there's any questions here that we've gotten. If there's any questions, please let me know. We're at the end of our presentation here. And I do have a few resources for you. So if you are a member of CEA, you have access to a drug testing toolkit. It goes through a lot of what I just went through. There's a checklist there that goes through step by step what to do. So it's a toolkit that has that information, but it also has that checklist, and it'll force you to answer some questions on there. If you don't have that, make one and include the various different reasons already pre-populated there, and then also add there that there's additional ones that they can cite. We also have an attendance toolkit, because a lot of times we don't know there's a problem with drug and alcohol. Maybe it's an attendance issue that we have. And then we also have a workers' comp toolkit that's available to members, because again, this could become a workers' comp situation which we don't know they were under the influence. This is a workers' comp, and then we learn that there might have been an issue or a concern or a problem. Our CEA University also has online training, forms, policies, articles, employee memos, so anything that you might need is also under our HR forms there. And then you have us. So everybody has access to the HR directors because you have access to the hotline at Alameda County. So definitely give us a call at Alameda County if you encounter this problem. Again, if it's 8 to 5, we're going to be available to answer your questions and kind of go through some of those reasonable suspicion steps. We have our CEA membership information up here. If you need additional support, we offer annual plans and we also offer monthly plans that start at $109 a month. And that gives you access to all those forms that I talked about in addition to many more things. If you have the ultimate plan, you actually also get our employee handbook. Which it gets updated every year with the information. And if you haven't updated your handbook this year, even if it's just your own, make sure that you have the cannabis protection under the classifications and that you also have amended your reasonable suspicion policy and your drug testing policy to make a little disclaimer that off-site cannabis use is not included in the policy. We want to thank you at Alameda County for logging in today and sharing and participating in our webinar. Well, like Carmelo said in the beginning here, you have this complimentary HR hotline that you can call for a variety of reasons. So please give us a call. I think I've talked to a few of you out there. So give us a call. We provide everything from hiring and firing processes, things on leave of absences, which can be very tricky in California, meals, breaks, overtime. If you're under any kind of suspicion about, I'm not sure what to do, give us a call. It's a free call. It's usually a 15-minute call or less. And if you need that additional support, we can also provide that for additional costs. So thank you for joining us. If you're here for continuing education, we do have the HRCI and SHRM codes that I'll put up here. HRCI 664828 and SHRM is 24-FAV5Q. And I will throw it back to you, Stephanie. Thank you so much.
Thank you, Astrid. Thank you for popping that survey up on the presentation. This is the survey that I mentioned at the very beginning. Just snap a picture of that QR code with your phone. The survey won't take you more than a couple minutes to complete. It's just a couple questions. We would love to get your feedback on this presentation, any topics you want to hear in the future, or ways that we can help improve. And just a reminder, if you do think back on any questions you might have for Astrid, give us a call on the hotline. One of our experienced HR directors will be here Monday through Friday, 8 to 5, to take all your calls. Thank you to the Alameda County Workforce Development Board for providing such a great resource. All right, and that is all we have for you today. Please go out, have a wonderful rest of your day, and we'll see you later. Bye, everybody.